Please be seated. Welcome to the First Court of Appeals. We have one case on today's oral argument submission docket. Case number 0122-00613-CV, ROC Houston, PA, DBA Reconstructive Orthopedic Center of Houston, and ROC ASC LLP versus Dush Parameswaran, MD. May I have appearance of counsel, please?
Martin Siegel for the appellate. Afternoon, Ed Harrell for the appellee, and I'm going to call Dr. Parameswaran Dr. Param because that's the way he asks his patients to refer to it. It's a lot easier on the tongue.
It'll save a little time, too. Have you reserved time for rebuttal?
I have, yeah, 5 minutes.
5 minutes. Okay, you may proceed.
Thank you.
May it please the court, my name is Martin Siegel. I represent the appellants, ROC Houston, that's Reconstructive Orthopedic Center of Houston, and ASC, an affiliated but separate business. The ASC stands for Ambulatory Surgical Center. This case is about reading contracts as they are expressly written. There are two contracts at issue in the case. One of them is an employment contract between Dr. Parameswaran and ROC. That dispute turns on a payment term, which we'll discuss. Second contract is a loan agreement between Dr. Parameswaran, other members of that practice, and this other entity, the Ambulatory Surgical Center. But our position on both contracts is the same. That is that they are unambiguous, and that if you read them as they are written, that requires reversal and rendering judgment for the appellants and remanding for an assessment of attorney's fees.
On the employment agreement, considering that your argument, actually it seemed like both sides agreed that it was unambiguous.
We did, that's right.
I was struggling a little bit to understand why so much parole evidence came in at trial regarding that contract and what it means if it was unambiguous.
Right, I mean, I think that evidence for the most part came in on behalf of the other side, and we certainly argued before trial and during trial that it has an unambiguous, certain, and definite meaning, and if you construe it that way, we were entitled to judgment as a matter of law. So there is, the parties, both Dr. Masson, who's the owner of the practice, and Dr. Parameswaran talked about their relationship and how the contract came into being, but we certainly don't rely on parole evidence here. We rely on the plain terms of the agreement, and we think that forecloses the jury verdict. So talking about that contract, as I said,
I'm sorry, before you move on
yes.
The employment agreement, while both parties concede that it's unambiguous, you did not get a trial court finding on that issue.
She found that it was unambiguous. She held that it was
employment
unambiguous.
agreement?
Yes, the employment agreement, yes.
And are we bound by that determination in the parties' agreement?
I mean, whether it is unambiguous is a question of law, so I mean, that the court could ultimately decide otherwise. I don't think it binds this court, but it's telling that both sides thought it was, and so I think it's teed up for the court to decide what these disputed terms mean.
But if we were to find that it was unambiguous, are we even able to send it back based on the relief that the appellant requested in briefing?
The relief we're requesting is that you find it's unambiguous, find that forecloses.
I meant to say ambiguous. I said
yes.
Unambiguous, didn't I?
You said
I meant
unambiguous.
to say if there was some reason in between
yes.
These arguments that we determined it potentially needed to go back, are we limited in any way based on how your prayer for relief is articulated?
I mean, our prayer for relief is certainly what we want. I don't think our prayer for relief binds the court. I mean, again, ultimately it's going to be the court's decision as to whether it is unambiguous or ambiguous. We think, tried below on the theory that it was unambiguous. That was the position both sides took, and we think a clear reading of its terms renders only one result. So I hope that answers Your Honor's question. Turning to the main term at issue, that's the payment term. That's 3 sentences that are crucial there. First sentence says that Dr. Parameswaran will be compensated according to the standard compensation model. And then the next two sentences explain what that model is. Second sentence is more specific than the first. It says that your payment is your amount that you achieve less, it's your collections less your pro rata share of expenses. And then the third sentence is the most specific, and it defines pro rata share of expenses, and it says expenses shall be divided evenly. So starting at page 25 rather, of our brief, we flesh out what we think the phrase divided evenly means.
So could you discuss the relationship of that definition of expenses, evenly and pro rata expenses found in paragraph 1, with the description of expenses in paragraph 7, which says pro rata expenses divided as if they're all equal partners. And I guess what I'm thinking, trying to hash out, is if you have the description of expenses in paragraph 1, and then a subsequent definition of expenses that specifically incorporates the term equal, as in equal partnerships.
Mm-hmm.
Doesn't that imply that in the first usage we're thinking of it as an equal division as well?
Yes, sir. I think, I'm not exactly certain where the other reference in the contract is that you're referring to. Paragraph 7 talks about waiver as I see it, but it is true.
It's a purchase price for buy-in.
It's an attachment
Attachment
A.
A.
I'm
Number
sorry, it's
7.
in attachment A.
Right, so,
Right. So it's attachment A, which has the two definitions. First one in paragraph 1, base
Yes.
compensation, and then we compare that with the, thank you, just count, for the physician's collected revenues and his pro rata share of expenses, open paren, calculated it as if he were an equal shareholder, close paren. So that seems to contemplate that the way to calculate expenses. Are they talking about the same pro rata division of expenses?
well, let me start by saying that as I understand the question, that does support our argument. And that expenses were to be divided equally among the members of the practice. That would be, for most of this time, that was 25%. There were 4 of them, so it's 25% each. Dr. Masson testified that he viewed this scheme as a sort of partnership-like arrangement. He wanted to encourage eating what you kill, so that you would go out and get as much revenue as you could, and that would be subtracted based on everybody's even division. So I do think it supports our reading. I think paragraph 7 has to do with becoming a partner, actually formally becoming a shareholder, which he was not when he was paid as an employee.
But
So
we still have a definition of expenses, right? And are these talking about the same, slightly different language?
Yeah.
But are these two talking about the same type of division of expenses?
I think so. As I read it, I believe so, but I do think the more applicable provision is the one that directly covers his
that's-
payment as an employee.
Right.
Yeah, so I don't.
We're trying to get how this term is used.
Yeah.
How is pro rata division used?
Yeah.
And it's used subsequently in the contract as well. And is being used in the same way, or are they two different definitions?
It seems to me it's being used in the same way, but I would say if there's any if the court disagrees with that, or if there's a conflict, the provision that really governs here is the one that directly controls his compensation as an employee. So looking at this now, as I read this, it's not, to be honest, the section we focused on because it has to do with a different scenario, but as I see it, I think it's exactly the same. The same expenses are referred to there. I think they reinforce each other. But if the court reads it differently, I don't think it matters, because what matters is, the compensation terms.
Why is Dr. Perrin's interpretation of the word evenly as used in paragraph 1 unreasonable? In other words, his argument that the expenses are to be divided evenly, the same, and so when the cap was implemented, everybody was being treated evenly, the same.
Right. He argues that, I think what you would have there is you have the same method. That's true. That's his argument, is that this is even because it's all being figured out the same way. The percentage of collections for me was 14%, so it's 14% expenses for me, and same for somebody else. That's not what the term says. The term says you divide expenses evenly, not that we have an even methodology or overall even formula, or that the formula is the same for everybody. It's much more specific than that. It says you divide expenses evenly, and really that can only mean one thing. Evenly means equally. There's, again, sort of ample dictionary support for that and ample case law support for that in partnership-related cases, in divorce. Often you see that phrase in divorce decrees, so you find out exactly what they mean because they'll quantify what each side is getting. So I think there's no real question about that. And frankly, the main argument the other side makes, as I understand it, is not so much that we're wrong. They sort of take a stab at that, and they talk about the meaning of the term. Really, though, I think the key argument is that you shouldn't enforce it as it's written because that would generate an absurd result. That's something they rely very heavily on. So let me just, in my remaining time, address that. That is a really...
Actually, why don't we go to the second?
Sure, thank you.
So we have a whole second contract to talk about. And of course,
yes.
that the perceived ambiguity in that particular contract is whether, essentially, employed in any capacity
Right.
means employee in the employer-employee relationship.
Yeah, well, it says employed in any capacity by the borrower, so that would be the ASC in this case. So you have to be, I think the way we read it, I think it's the only way to read it, is you have to be an employee in any capacity, true. But that could be, in some other way. You could market for them. You could go out and...
Would that include an independent contractor?
No, I mean, an employer is always, or employee is always different by law than an independent contractor. You have to be an employee to be employed.
Well, you have to be an employee. I mean, do you have to be employee to be employed? Why didn't they just say an employee, which would clearly mark it as within the employer-employee relationship?
Right. So I think they did say that, and I guess Your Honor's alluding to the phrase "in any capacity."
Right.
But that modifies employed, and employed can only mean one thing. I'm an employee. Now we could debate whether you are or you're not, but you have to be an employee.
Mr. Siegel,
and there are lots of capacities he could have, in theory, like I said, he could have done administrative work for it. He could have done marketing, something other than simply.
So you're saying capacity means job duties, not
Sure.
necessarily a legal relationship.
It means it could be part-time. It means some form of employee. There are lots of different kinds of employees. So it means he's covering the waterfront of the kinds of employee. But
Right.
you have to be an employee.
So none of these four principles were employees then?
Correct.
Well, then how do we not render as surplusage the provision on the next page of the contract that says the penalty for the distribution,
it's 3.4A.
right, the
Of
repayment of
the
principal and interest, section 3.4.
Mhm.
If nobody can ever be, if none of the principals or the obligors on the loan can ever be terminated, then how is section 3.4 not just rendered as surplusage?
I think because when this was entered into, it's true they were not employees. They could have become employees along the way. So it was not an impossibility that they were ever going to be employed in some capacity by the ASC. That could have happened. In fact, there's a provision in the the employment agreement. The only reference in the employment agreement as it happens to the ASC is a provision that mentions possible buying into the ASC. So
That makes him a shareholder, not an
Sure, but-
employee of ASC. And
Yeah.
if I recall, there was some testimony that the ASC, for legal purposes, could not employ the orthopedic surgeons for legal reasons.
Well, I think that goes to, I don't think that covers all kinds of jobs there, actually, and I could be misremembering the record there, but I guess the point is I don't think it's surplusage because circumstances could have changed and there could have been a scenario where they were employed in some capacity.
And was that in the contemplation of the parties at the time of contracting?
I don't know that there's evidence to that effect in the record, Your Honor. And again, we think that would be irrelevant anyway because we think this is an unambiguous contract and the word employed is quite clear and there's no real...
Did the employment agreement create an employer-employee relationship?
Certainly, yeah, but with the ROC, with a completely different entity. And that's quite telling. That's part of the reason we think can't really claim he was employed by the ASC. He had an employer, and that was the ROC. And the ROC doesn't say anything about, again, its only reference to the ASC is to reinforce its separateness as an entity because they talk about possibly buying into it. There's also, of course, the time-honored test of employment in Texas, under Texas law in a lot of scenarios, is control. And you can't seriously argue, I don't think, in this record that the ASC, which is just a place where they did surgeries, controlled his work. The ROC controlled certain aspects of it, and then as a doctor, of course, he applied independent medical judgment as to how he practiced medicine. So the ASC is not his employer, and he said as much in testimony. He was asked to list his employers, and he said he weren't paid or employed by the ASC. So it's an odd loan agreement, admittedly. There was another provision for him to get repaid. That was if they sold the land. But he does not qualify as a terminated employee. Thank you.
Any further questions? Thank you, Mr. Siegel.
Thank you.
And Mr. Harrell, you can have an additional 3 minutes, should you choose to use it.
May it please the court, counsel. Ed Harrell for Dr. Parham. I'd like to start where we left off, that's the loan agreement. Because I think it's very, very clear that terminated lender can only have one meaning under the compensation provision. It says, buy me out when I am no longer employed by the ASC. Clearly, the appellants want it to be a Texas common law employee, but that's not what it says. Clearly, to no longer be an employee, one must have been previously to the loan agreement an employee, because therefore you could not have no longer been so. I suggest that the language is clear. Employed means used. That's the commonsensical way it's done. And not only is it commonsensical, that's the way this operation was run. You had the clinic piece, which is the PA. You had the ambulatory surgical center where they conducted surgeries.
So your position is that the term employed is not ambiguous and does not include the employer-employee relationship.
That's correct. And don't get me wrong, we argued below and pled that it was an ambiguous term as an alternative to their claim that they had made continuously that employed has to mean employed as a Texas employee. There's nothing that suggests that, in my view, under the terms of those words, because it makes absolutely no sense that the trigger is when you are no longer employed in any capacity. And capacity just means how did the ambulatory surgical center use these physicians?
So just procedurally here
Sure.
to start to suss things out. So your argument would be that it was erroneous for the trial court to find that it was ambiguous, and it was therefore erroneous for the trial court to submit that jury question asking about employment.
As I say, it matters not. I understand that that's the logic and the thrust of the argument, but it's simply rendered irrelevant, because if it's not ambiguous, then it is unambiguous. And I suggest it is unambiguous. And so the instruction and the jury finding can just be ignored, because it really doesn't matter.
So we would treat the jury question as surplusage.
Yes.
And the rule as a matter of law that employed does not necessarily implicate an employer-employee relationship.
The alternative is, if it did, then both are reasonable. I mean, that's the other side of the coin. If it's ambiguous, if both readings are reasonable and the jury found otherwise, that he was in fact at the time of the loan agreement employed in some capacity by the ASC.
So what in the employment agreement would suggest that evenly does not mean equally?
I'll have to start at the beginning. And when I say the beginning, those three sentences in the compensation paragraph are the key. And it starts off with, you're going to be compensated according to our standard model. Well, if you look at the employment agreement, there was nothing standard about it in this sense. He was paid a salary for the first 18 months that Park Plaza Hospital, in fact, advanced to the PA for some reason. The Dr. Masson testified that he persuaded him. It's not in the record, but other than that. Then the second piece is, then, that's the only way you can read the compensation paragraph, is after the salary piece, then you're going to be paid your collections minus your pro rata part of the expenses. Now then, in their brief, they concede that The standard model is indefinite. They concede that pro rata is also indefinite because it doesn't tell you what it's ratable to. But I suggest to you it's ratable in the same way that it was done later. When I say later, after the salary piece ended.
But it says pro rata share of expenses. It is relatable to something, to the expenses of the ROC.
I think it's as measured by the physician's usage of the resources of the ROC, PA, or the ROC. And that's exactly what it was done. If Dr. Masson was...
Okay, well, setting aside what was done, we're concerned with interpreting within the four corners of the contract.
Understood.
So, is there anything in there that would suggest that pro rata does not mean per capita, or that pro rata and evenly together does not mean equally?
I think the answer is yes, and the reason it's yes is because of the usage of a model followed by a pro rata. Of course, if it's going to mean something, it has to be pro rata to what? And I suggest that the language tells you that pro rata means ratable to each physician's portion of the revenue. And also, it says...
But they could have said that.
And they didn't.
And instead they said evenly.
Here.
Instead of making it, I mean, it's just because the business deal does not benefit the party does not mean it's an absurd interpretation of the business deal.
I appreciate that, and I understand their argument. However, I suggest that under a pro rata standard compensation formula, even means alike, the same. I think Justice Remus-Molloy suggested. And that's in keeping with those three sentences, because what they would like to do is isolate evenly.
But Mr. Harrell, when we read that last sentence, expenses shall be divided evenly, it doesn't say expenses shall be allocated evenly. It says divided evenly. So how do we take this language and apply it to your interpretation? It's to be divided and not allocated fairly or evenly.
I think the answer is that evenly must mean something other than, since there's four physicians, 25, 25, 25. I think evenly doesn't mean that. It doesn't mean it.
But that's the point. What does it mean? We have nothing in the contract that tells us what that means.
I think the answer is in those three sentences, and the three sentences say allocated ratably.
What about expenses of the surgery center? Nothing specifies here what's actually included in collections.
That's true.
Or what isn't included in collections.
It doesn't specify, but it doesn't say they're to be excluded. His collections, and in fact, proof in the pudding was his collections were in fact measured as a piece of the surgical income, surgery center income. And so his collections is not limited, his collections under the PA, his collections for X, Y, or Z. It just says his collections.
Mr. Harrells, I understand that, and maybe you can correct me on this. They were including Dr. Parnham's collections for his surgery services from the ASC. What was not being included and what ROC contests should not be included are the facility fees that ASC was collecting for usage of the facility. And in fact, Dr. Parnham was not a shareholder of ASC, so presumably he wouldn't have been entitled to those fees being allocated as his collections under the employment agreement.
Well, there's nothing that says that his generation of the facility fees through the usage of his patients being operated on in the facility wouldn't be attributable as part of his revenue / collections. Even if the charge was made by ASC that ASC was then being billed for billing, the PA as well for that. And so there's nothing inconsistent within the four corners to suggest that you bring in both the revenue generated by my surgeries and the costs associated under the ASC with those surgeries. And that would be net, that would be my net collections from those. And I'll concede it's after the fact, but that's what the practice did consistently, every single time. All these reports that were generated in-house, not by Dr. Harley, that's what they did. They brought in his collections from the PA and his portion as measured by his surgeries from the ASC. And so, was it done right then and there at the time of the assignment? I can't say that. But I can say that you can read the compensation agreement to actually what it was in the practice, which was his standard. I say his, it's really Dr. Mason's standard compensation model, which he basically testified as it's anything I want it to be.
Is there anything about the surrounding circumstances in coming to this employment agreement that, you know, came in at trial that we could also look to that is not parole, that maybe doesn't fall over? I know can be a blurred line between parole evidence and surrounding circumstances, but what would you say we should maybe pay attention to?
I think, number one, you have a brand new physician, newly licensed in Texas, who is just starting his practice. And so he is at the very, very beginning of his career. And what is going on with the practice is at the time he's being told that there's a standard compensation model. There's no question about that. And Dr. Mason testified, well, you know, I had a discretionary bonus. And I just decided if I had the money, I would pay the physicians as an incentive. Now, is that part of the record in the sense at the time of the discussions of 2010? I can't say that because I don't. That's what he testified.
Yeah, no,
that's what it was. And I don't want to talk outside the record.
Right, I understand.
But that is part of the evidence that equaled, in his mind at least, the standard compensation model. And so,
Mr. Harrell, maybe this is what I'm struggling with, right? The position from Dr. Parnas, I understand it, is this contract is unambiguous. So given that position and the argument in the appellate briefing, what case would allow us to then go into usage and trade to otherwise alter, amend, or to add to these provisions, which both parties have argued are unambiguous on their face? Because as I see the law is we're not allowed, you know, at this stage to look to that extrinsic evidence on usage or trade other than looking at the four corners of the contract. It may be that there's these side agreements or that for whatever reason Dr. Mason agreed to compensate Dr. Parnham differently than what the contract required, but we're required to look at the contract and what the contract required for purposes of the breach of contract claim.
But first of all, I don't think the lower court held one way or the other on the ambiguity of the employment agreement. But it is absolutely correct that neither side argued that it was ambiguous. And I'm talking about the appellee side as well. And you asked the question earlier, I believe, Judge Rivas-Moroy, about does that allow us to ignore that in fact it was ambiguous? And the law is yes. Even if both parties say or don't argue that it's ambiguous, then the court of its own accord, and I have a case, I don't think it's cited I know it's not cited in the brief. I always have to send a letter to the court with its permission to give you the citation in that case. But I also want to talk about, there's another reason. Texas law, especially employment law, relative to the employment agreement, has a concept of unilateral contract. Is it in the record set that way? No, and it's not in the brief, I agree. But this is the way it works. You change a term of your employment. Your employer changes the term. Then you have a choice. Continue working and you accept that change, or you quit.
But both these contracts have merger and integration clauses in them. So it doesn't matter what the practice is after the execution of the contract. We're still stuck with the plain language of the contract, no matter how unfair it is, because there has not been a written modification signed by the parties.
Well, I agree that that's a term that is used in the employment agreement, that an amendment requires that. But I suggest that Texas law says, irrespective of that if there's a change, the employer can insist upon it, whether they're in breach of an agreement or a policy or whatever, it doesn't matter, because the employee...
So that's a ratification concept, right? That by continued employment, you're ratifying the unilateral modification of the contract by the employer. But I don't know if that really obtains here, especially when you have sophisticated arm's length parties entering into a business transaction. More than just someone working at a store or something like that. This is a...
Well, I would suggest that the law is not limited to blue collar workers, for lack of a better word. I don't think it matters the level of sophistication, that if you're put to the choice, then in fact you can accede to the choice, even if it's beneficial or unbeneficial to you, and thereby create a unilateral contract and a unilateral obligation by the employer to follow that contract.
And that would, of course, maybe be the case in an at-will employment situation, or where there is no existing contract. But how does it apply when we have an existing contract, again, with the merger clause, and a requirement that all amendments be made in writing?
Well, I appreciate that. And I would just say that the case law, I believe, is such that irrespective of that, when you're talking about employment at will, and this was an employment at will contract, by the way. If the term of the employment agreement was at will, there was a notice provision, but nevertheless it was at will. Either party could terminate at will, period.
Terminate at will, but not necessarily modify at will.
If you mean a written amendment signed by the parties, I
That's
agree
what the
wholeheartedly
Texas Supreme
that
Court
that
seems
was
to
not
require
done.
that, so-
Justice Kelly, it wasn't. It's not in the record, and it was admitted by Dr. Parham that it was not done. Agreed. But I think that the jury's decision, they listened for 5 days, it should be upheld. Because what this really boils down to is an attempt to nullify the findings of the jury. Now then, is that part of our, quote, absolutely unfair type argument? Perhaps. But I suggest that they let all this parole evidence in. They didn't complain about the admission of any of that parole evidence in their brief for this court. And so I suggest that that parole evidence is in. It was considered by the jury, and I suggest that the exhibits and the testimony should be considered as well in upholding the the verdict.
Any further questions? Thank you, Mr.
Thank you.
Mr. Siegel, you may proceed.
I'm not completely sure I understood the argument there that Your Honor, I think, correctly as I understood it, labeled the kind of species of ratification. I guess all I would say is, respectfully to Mr. Harrell, I think that argument has been waived. It's not briefed by the other side. It's not one of the reasons they've offered. I know you can affirm on other grounds, but we've had no opportunity to respond to that. I'm not.
Well,
I don't think that's before the court.
How about each of you present within 10 days, briefing on that particular issue, not to exceed 3,000 words, and if waiver is your key point, you can address that there, because we're not going to address it in the next 4 minutes and 22 seconds.
We have no objection to that, Your Honor. I'd only ask that we get, as I said, I don't fully understand the point. That we get to respond.
Each of you.
Sequentially. In other words,
Yes.
I can't brief it at the same time. I don't
Right.
know what we're responding to.
Right, I'll be clear. Both of you file something in 10 days, and then 5 days after that, each of you file a reply to each other's.
Your Honor, I'd be hard pressed to file something. I don't know what that is. I don't know what I'd be saying. I didn't follow the argument. I really don't understand it. So.
All right, then we'll just do it the
is-
standard way. You brief
Yeah.
it 10 days, you respond 5 days after that.
That's fine. That's fine, Your Honor. So, phrase Your Honor used, I think, in our argument, and then Justice Reeves-Molloy, I think you used it as well, is within the four corners. This has to be decided within the four corners. The law, as Justice Kelly has described it, is that subsequent performance, when there's a merger clause, and in general, even without a merger clause, I believe subsequent performance is not, does not alter the plain terms of the contract, and both sides agreed the terms of this contract are plain. There is not, yes, there was testimony in the record as to how this deal developed and how their relationship went along. It's not parole evidence that we consented to vary the terms of the contract. Of course, our consistent position has been this is unambiguous and the court should construe it as a matter of law. We asked, but they agreed, and that's what happened. So it was not admitted.
I think the principle is that there is such a thing as ratification by conduct. Does that apply in this circumstance? And
I think Your Honor answered that question, which is it has to be a written modification, and we have the merger clause.
That is my sense, but
yes.
I don't have Westlaw up with me right now, so
yes,
I want to give the parties an opportunity to address that.
Great, thank you, Your Honor. Counsel referred a couple of times to the first sentence of these three sentences about compensation, the reference to the standard compensation model. He used the word model. But the court knows, and we stressed this in our briefing, that the specific controls the general. The phrase compensation model has no real meaning. Indeed, as counsel said, he could be altered at a whim. It could be.
Well, specific controls over the general when they conflict. That one must, if they can be,
sure.
Made to coexist, then you apply both. But only when they conflict, the specific control over the general.
Well, I think the conflict is being suggested by the appellees. We think the specific is quite clear, and they're using the general to perhaps have it mean something else. And the specific here is divided evenly. And again, Justice Molloy, Reeves-Molloy, as you pointed out, it's expenses that have to be divided evenly. Now, it was suggested that evenly could perhaps mean the word alike. But again, there's no dictionary definition to that effect. There's no case law to that effect. Courts are supposed to construe terms in contracts. The standard tools are dictionary definitions and then usages in law. And evenly, we've I think, probably to your annoyance, buried the court in references to what divided evenly means in federal cases and state cases and dictionaries in a lot of different settings. I think hopefully that's fairly clear. I want to address the question of the facility fee and including ASC collections, because that was mentioned. There is no mention in the employment agreement where his compensation is derived from and calculated to collections from the ASC. Now, as Your Honor pointed out, I think there's a distinction between the facility fee and the professional, what's called the professional fee. And that's payment to Dr. Parmesan for actually performing the operation. And that should be included. It was included, and we have no argument with that. But what they want to also include is this entirely separate stream of payments that went to this different business, the place that just housed the operations for expenses for overhead and things of that nature. And that's not mentioned or contemplated in his employment agreement in any way. I'd also like to talk about surrounding circumstances. I think, Justice Karas, you mentioned that. Surrounding circumstances are supposed to be objective. Usually it comes in through an expert in the field testifies about something, or trade manuals, things like that. There's no such evidence in this case. The surrounding circumstances that were offered, at least as offered in the briefing, has to do with just the idea that he should have made money. The orthopedic surgeons are compensated well, and it was understood he should have been compensated. And so the surrounding circumstances, how could he be agreed to a formula that would have potentially generated no income for him? That is, as Justice Kelly, you said, that is simply a business deal that went wrong, that went in a way different than anticipated by one of the parties at the outset in 2010. In 2010, it seems that Dr. Parmesan calculated that after this initial 18-month period of the salary guaranteed amount of money was over, he would have grown his practice sufficiently to be taking in money, that the collections would exceed the expenses. That seems to have been a miscalculation, either because he overestimated how fast a new doctor could grow his practice, or he perhaps underestimated the expenses. But the absurd results canon doesn't save people from bad business deals.
And I know you're out of time, but I do have one question.
Yes.
If we were to agree with appellants that the employment contract was unambiguous,
yes,
and we reverse on that basis.
Yes.
In question number 5, the jury also awarded an amount based on the practice of Dr. Purnam outside of the practice.
Yes.
What is the consequence of that disposition on jury question number 5?
Right, I believe that comes to, as I recall it, we had a counterclaim, and that comes to us. I'd have to refresh my memory about that part of the record. I'd like to, if we could, address that in the briefing, the supplemental briefing we're providing. I believe, and please don't hold me to it, but my recollection is that was a breach of contract that we had argued. It was used ultimately to offset their recovery, but I believe that's a breach that generated income to Dr. Parmerswan he was not entitled to under the contract, that should have come back to ROC that didn't. And I can address that fully in that letter briefing, if that's okay.
Why doesn't a supplemental briefing include that issue as well? And we'll give 5,000 words for the initial supplement, and then 3,000 for the response.
Okay. Of course, I'm out of time. I don't know if the court would want me to address the one last thing about the ASC that was brought up in the other argument. It was.
I think we have your
Thank you.
parties' arguments, and ROC Houston, PA versus Dr. Parham is hereby submitted, and First Court of Appeals is adjourned. Thank you.